Wonderful. Today's topic, general family law questions. It follows up from our webinar we had this weekend. There were quite a few questions which I had to go through, a lot of live questions, people calling in and asking questions via the platform. And we thank everyone for doing that. Nonetheless, there are three questions which I chose, which I would like to elaborate further on, and hopefully we can all benefit and learn from that. Please note, our next webinar taking place on Saturday, part 3, the third webinar in the series. There will be 4 in total dealing with generally family law matters, child custody, child maintenance, and divorce. I hope that you have registered for the next webinar or partook in the previous webinars. Many people register and they do not obviously partake on Saturday because they have stuff to attend to, school, shopping, whatever the case may be. But nonetheless, if you do register, we will deal with your question. There will be a video posted later, and obviously whatever question you have posed was answered thereon. So you'll get a chance to ask a question to a family law specialist and have the question answered based upon what you provided. So that's great. So please remember to register. And those are the details. It will be on later on, and it's also at the bottom of my screen, what you can see in front of you. So let us begin today's webinar. General family law matters. 3 of the questions, I'll deal with the first question that was posed, and I dealt with it in the webinar. However, I'll deal with it again now for the purpose of today's webinar. And if you have a question, feel free to post it on the Advocate Muhammad Abduroaf Facebook page. Question 5 from the Northwest. How does an unmarried single parent get a passport for a 6-year-old child? The father cannot be found and the child is solely raised by the mother. Very interesting question, something which keeps me very busy at the office. Relocation, passport application, consent, and so on. So if we unpack that specific scenario, obviously this is a mother who's posing the specific question. She was never married to the father. The father cannot be found, but there is a minor child of 6 years old involved here. Very important. Now she would like to apply for a passport. I do not have any additional information, how involved the father was in the child's life in the past, how long has he been absent, and so on. Is he paying child maintenance, whatever the case may be. But that's the data which I have. In terms of the Children's Act, both guardians' consent is required for the child to apply for a passport, or for the parents to apply for a passport on behalf of the child. Now, the specific mother, she'll go to the Department of Home Affairs. They'll ask, where is the father? Maybe the father's details is on the birth certificate. I do not know. But they'll ask, where is the father? The mother will say, I do not know where the father is. The Department of Home Affairs will say, okay, we can't assist you. What if the mother is not telling the truth? What if it's not true? Maybe she knows where the father is, or maybe the father does not want the child to get a passport, or maybe she wants to use a passport to go overseas and leave the country, and the father does not want to agree to that. Nonetheless, the father's consent is required. So the Department of Home Affairs asks the mother to leave, say we cannot assist you. What happens then? The father is not providing consent. Now, in terms of our law, the court can override the father's consent. The court can dispense with the father's requirement for a consent for the minor child to apply for a passport. Therefore, the mother would have to approach the High Court in this specific case. She can approach the Children's Court, I believe, as well. They can maybe dispense with that specific requirement as well. But nonetheless, she will have to approach the court, and the court will either have to determine whether or not it would be in the minor child's best interest for the minor child to obtain a passport, despite the father not wanting to give consent or cannot be found. Now that brings a second problem here. The father cannot be found. Now, in our law, obviously, before any final decision can be taken, and in any matter, both interested parties, or all the interested parties involved, must be informed thereof, and they should give the piece of input, into the matter. Here the mother wants to apply for a passport, cannot find the father. Can she go to court and say, I do not know where the father is? Maybe she knows where the father is. But nonetheless, the court has to be convinced that the father has been informed about the specific application the mother wishes to make. In this specific case, having the minor child apply for a passport without the father's consent. Now, because I presume this father is in South Africa, there's something called substituted service, whereby she will serve this documentation on the father via the newspapers, the government gazette, and so on, whatever is directed by the court. If the father had to be overseas, they call it edictal citation, whereby you serve the father via a different means, either share the film in another country, or via WhatsApp, or email, Facebook. You can be creative. It all depends upon the court and what the court thinks is reasonable and fair under the circumstances. So let's say this specific mother, she files the application, she goes to court, the court authorizes via substituted service application that she can serve this documentation on the father in the newspapers, and hopefully the father will see the information in the newspapers or in the government gazette, and then the father will now decide whether or not to oppose it or not. If the father sees it, and it is presumably he had to see it because it was published, and the father does nothing about it after seeing it, and then obviously the matter will proceed on an unopposed basis because the father is doing nothing about it. If the father, on the other hand, in this specific scenario, sees the advertisement and he wishes to oppose it, he will obviously have to file his opposing documentation and advise the court why the child should not receive a passport. The court will listen to both sides of the story, the mother's case and the father's case, and then based upon that, the court will determine what is best for the child, and if the court believes it's in the child's best interest to obtain a passport, the court will make such an order. Remember, in our constitution, everyone has a right to a passport, so I do not think the father can really oppose an application for a passport. The father may be able to oppose an application for the relocation of the minor child to a different country, but that's something else. I hope that answered your question from the Northwest. It was dealt with in our webinar on Saturday, and I'm just dealing with it again today for the benefit of everyone. It's a lot of interesting topics and questions gets posed, as opposed to me presuming this is what the people want to know, but it might not be the case. Question number 9 that was posed in our live webinar on Saturday past. Can I change my marriage to ANC? Now, ANC would obviously be with an antenuptial contract. So if I can rephrase the question, may I change my marriage, which is currently in community property, to a marriage out of community property for the parties to enter into a postnuptial contract? And there's two scenarios. One, to a marriage out of community property with the inclusion of the accrual regime, and the other scenario would be a marriage out of community property with the exclusion of the accrual regime. So let me unpack that for you firstly. Let's deal with the basic marriage scenario. The basic scenario, or the normal scenario, for lack of a better way of saying it, would be a marriage in community of property, whereby once the parties get married, there's no longer two estates. The husband's estate and the wife's estate is one estate. All the debts, all the money, all the profits, all the assets get thrown into one pool, and that is it. So if you marry a lady of a gentleman who owes a bank 100,000 rand at the date of the marriage, that debt forms part of the joint estate, and the bank can come and take the money from the pot, and it will obviously mean that the husband, if he was a wealthier one and with no debt, he will ultimately, the money will come from his portion, which he contributed towards the joint estate. And people will say that that is unfair, but that is the law, and that's how marriage in community property works. At divorce, the joint estate gets divided and it gets split, or at death. So that's a basic, that's the normal, the standard marriage agreement contract would be in community property. Then we're dealing with the first scenario, which I mentioned early on. The alternative scenario would be a marriage out of community property with the inclusion of the accrual regime. Easier for me to first deal with the inclusion part, and the exclusion part will obviously mean without that. The accrual regime basically means that you share the growth of the respective parties' estate. During the marriage, should the parties get married, say I do, there is still two estates. Husband still has his estate, wife still has her estate. She can do whatever she wants to do with her money. He can do the same. They can enter into contracts, agreements. They can get into themselves into debt. They can be sequestrated, in the sense of maybe different terms like businesses, like liquidated. They can become sequestrated, whereby they cannot pay the debts, and that's fine. It will only apply to the Pacific estate. So the husband gets sequestrated, he does bad business dealings, it only applies to his estate. Doesn't affect the wife's estate at all. However, at death or divorce, that is where the cruel contract gets life. Basically, what happens is, if the husband's estate grew, let's say at the start of the marriage, his estate was worth 0. Now, at divorce or death, his estate is worth 1,000 rand. The wife's estate at the start of the marriage was 0. Or, for example, let's say it might be complicated, it was minus 10,000 rand, and at death or divorce, her estate is now 0. Now, you can only benefit from growth. So, what happens then? The wife would benefit of the growth of the husband's estate. So, his estate is now worth 1,000 rand. At divorce, she would get 500 rand, and he will keep his 500 rand, and that life goes on. Because her estate was 0 before the time, it's basically calculated as being 0. Sorry, because her estate was minus 10,000 rand at the marriage, start of the marriage, you basically calculate it as being 0. So there's no growth. You only benefit from the growth. Should the wife's estate, for argument's sake, have at the start of the marriage have been 0, and at the divorce it was minus 10,000 rand, the same principle would apply. She would benefit from the half of the husband's growth in the estate being 1,000 rand. So that's the first scenario of a marriage out of community property. Then the other scenario would be a marriage out of community property without the inclusion of the accrual regime. Basically meaning the accrual system doesn't apply. During the marriage, what yours is yours, what's his is what's yours is yours, what's yours is yours, that's fine. What's his is his, and what's hers is hers. My apologies for that. I'm getting a bit tongue-tied. At divorce, same principle applies. You do not share in anyone's debt or assets, as the case may be. The wife walks away with whatever she has, debt, assets, etc., and the husband does exactly the same. He walks away with whatever assets he has, debt, whatever the case may be. They do not share in it. So the question that you may pose is, what's the benefit of the accrual regime? The benefit would basically be, one benefit, if the parties get married and one party, for argument's sake, decides to stay at home, let's say in this scenario would be the wife, and she looks after the children, she is a home executive, she cares for the home, she irons her husband's shirts, make sure there's nice warm food on the table while he goes to work, while he's making the business, he's making money, he's earning a living and he's acquiring wealth. But what does she know? She knows, what? While my husband is working and making the money, and I'm at home ironing the school shirts, taking the kids to school, cleaning the house, cleaning the windows, whatever the case may be. If my husband divorces her, my apologies. If that does happen, the wife will get half of his wealth, whatever has accrued in his estate. So she knows that. And the same applies at death as well. So she will get her portion. So that's the one advantage for a marriage with the inclusion of the accrual regime. One spouse can go out there and make the millions, whatever the case may be, but the other spouse knows, should anything happen, I will get my portion of the millions. So the question is, can I change my marriage to antenuptial contract or postnuptial contract or married out of community property with accrual or without accrual? Yes, you can do it after the marriage. It's possible. It is an application that gets made to the High Court where the parties reside. It's very important to note that it cannot be done in the Magistrates Court. It needs to be done in the High Court. Notice must be given to all creditors from both sides. And at the same time, you need to serve the documentation on the register of deeds as well, in case it's property registered and so on. So it is possible. It can be a bit expensive. Lawyers are generally expensive. However, you'll have to place the notification of your intended change in the matrimonial property system in the government gazette. Can be quite expensive, and to local newspapers that can be expensive as well. That is a requirement, and also serve the documentation on the register of deeds and get a report from them. That also costs some money. Therefore, the long and the short of the matter is it can be very expensive. But it's possible and it can be done. It does not take that long, a few weeks if the courts are operating normally. Nonetheless, you also have to enter into a post-nuptial contract. So when you draft this application, you will stipulate this is what you intend to have, a marriage other community property with or without accrual. This is how we are now dividing the joint estate. This belongs to him, this belongs to her. And then that's it. The court makes it an order and you have 90 days to register it at the deeds office. So you need to obviously make sure that you follow the rules applicable to that, but it is possible. So I hope I'll answer the question again for question 9, Western Cape. Thank you for that. And the last question, question number 12, which was part of the questions in the webinar last weekend, Saturday past. Why do I need to undergo a blood test if I am not the father of the child? I presume we're applying here to a child maintenance court case. Of course, you are saying you're not the father of the child. What if you are the father of the child? The maintenance matter, well, obviously, the maintenance court obviously wants to finalize this issue. We do not want to have a father who makes a mother pregnant, walk away and deny paternity and be scot-free. If he is a father, he has a legal obligation to maintain the child. But if he is not the father, there is no such obligation. Therefore, we need to determine the paternity. Blood test, there might be other means of doing so, DNA tests, whatever the case may be, but it needs to be done in order for us to confirm or disprove paternity. So it needs to happen. And it needs to happen as soon as possible, because if the child requires child maintenance, we cannot delay the matter. Please don't forget to register. I will put that up a bit later on and we can deal with that. If you have any additional questions, feel free to post it on the Advocate Mohammed Abduroaf Facebook page. I see we do not have any. Otherwise, I shall see you online on Saturday. Please visit the link in front of you, and thank you for joining this webinar. Have a lovely day.